Step 2, arrest. Once a police officer has obtained suspect into custody for the purpose of charging him with a crime. While this definition makes the arrest the first step in the charging process and the first step in ensuring the person's presence at any prospective trial, it also plays an important role in the continuation of the investigation of the crime. The arrest allows for a search of arrestee's person, which can disclose incriminating evidence. And as discussed in Step 3 infra, it facilitates investigative procedures that require the participation of the suspect. Police may have various options in dealing with a situation in which an arrest is authorized. Initially, as an alternative to a full custody arrest, many jurisdictions authorize a police officer to briefly detain the suspect and then release him upon issuance of an official document commonly called a citation summons or appearance ticket, which directs the suspect to appear in court on a set date to respond to the charge specified in the document. In most communities, this release on citation alternative is only infrequently used, if at all, for felonies, in contrast to misdemeanors where it is used fairly common. Secondly, the police may have the option of making an arrest with or without an arrest warrant. A court order authorizing the police to arrest a particular person. In some circumstances, the law may require that the police obtain a warrant unless there is not ample time to do so. The warrant is obtained by making a showing before a judge, typically a magistrate, that there exists probable cause to believe that the prospective arrestee committed the crime for which he will be arrested. In most circumstances, the police also have the option of making an arrest without a court authorization in advance, a warrantless arrest, although a showing of probable cause then will have to be made subsequently to magistrate court. Step 6 infra, when the choice is available. The clearly dominant practice in all jurisdictions is to proceed without first obtaining a warrant. In making an arrest, the officer's first task is to secure the arrestee, using force if necessary. The officer usually will then search the arrestee's person and remove any weapons, contraband, or evidence relating to the crime, although some agencies encourage use of only a frisk for weapons rather than a full search in certain situations. Under the appropriate circumstances, the search incident to an arrest may be extended beyond the person of the arrestee to include a contemporaneous search of containers being carried by the arrestee, i.e. a purse or package, the passenger compartment of a vehicle, the containers therein. In the case of a roadside arrest of the driver or passenger, and that portion of a room that is within the reaching distance of an arrestee while the arrest is made within a structure, for example, a residence or office. Once the search incident to the arrest is completed, the arrestee will be transported by the arresting officer or other officers called to the scene to a police station or similar holding facility. It is at this facility that the arrestee will be taken through a process known as booking. Initially, the arrestee's name, the time of his arrival, and the offense for which he was arrested are noted in the police blotter or log. The arrestee then will be photographed and fingerprinted. After that, the arrestee ordinarily will be allowed one telephone call. Once the booking process is complete, the arrestee will be placed in a lockup, usually some type of cell, pending his subsequent presentation at the first appearance. Before entering the lockup, the arrestee will be subjected to another search, often more thorough than that conducted incident to the arrest, with his personal belongings removed and inventoried In some jurisdictions, persons arrested on lower-level felonies can gain release from the lockup by meeting the prerequisites of a station house bail program, making a cash deposit in an amount specified by a judicially approved bail schedule, and agreeing to certain conduct restrictions, including appearance in court on a specified date. Step 3, post-arrest investigation. Not all of the post-arrest investigative procedures that may produce further evidence of criminal activity will necessarily have to be designed for that purpose. Concerns such as guaranteeing officer safety and the protection of valuables will play a role in several standard post-arrest investigative practices, such as the search of arrestee's person incident to both the arrest and the placement of the arrestee in lockup, and the search of the arrestee's automobile where it is impounded. Most post-arrest investigative procedures, however, are aimed solely at gaining further evidence that the defendant committed the identified crime, and whether they are used depends in large part on the strength of the evidence obtained prior to the arrest. Many of these procedures could have been utilized prior to the arrest but were postponed until after the arrest as they were not to establish probable cause. See FN 11 Supra. Others, however, will be procedures that build upon information and evidence that has been obtained as the result of the arrest. Example, a forensic examination of a weapon seized in search incident to an arrest. One critical source may be available by the arrest itself is the person of the arrestee. That source allows police, for example, to obtain eyewitness identification by placing the arrestee in a grouping of physically similar persons shown to a witness, a lineup having a witness view the arrestee individually, show up, or taking the arrestee's picture and showing it to the witnesses, usually with photographs of other persons in a photographic lineup. Similarly, the police may obtain from the arrestee identification exemplars such as handwriting or hair samples that can be compared with evidence found at the scene of the crime. As the arrestee is now in police custody, police questioning of the arrestee also is greatly facilitated through custodial interrogation, although custodial interrogation does require that the arrestee be advised of certain rights, including the right not to respond, and that he agree to forego those rights. Step 4, the decision to charge. For the vast majority of felony cases, the initial decision to charge a suspect with a crime is made when a police officer makes a warrantless arrest of the suspect. That decision may be reversed on internal review within the police department, typically by the booking officer. Police departments vary in their willingness to authorize that authority. Some will decide against charging and immediately release the arrestee only where the arrest is clearly an error, while others will more fully evaluate the available evidence and reject proceeding where probable cause may exist. The reviewing officer concludes that the offense can more appropriately be handled by a station house adjustment, reconciliation with a family member or victim, or the arrestee's willingness to become an informant. Even where the police agency provides an in-depth internal review, only a very small percentage of felony arrests will be rejected within the police department, although a somewhat larger percentage of felony arrestees are likely to have their booking charge reduced to a misdemeanor. The ultimate authority over charging arrests with the prosecutor rather than the police. The prosecutor is engaged in an ongoing evaluation of the charge throughout the post-arrest criminal justice process, but the prosecutor's decision not to go forward on a charge requires a different processing action depending upon whether that decision is made. 1, prior to the filing of the complaint, step 5, infra. 2, after the complaint is filed and prior to the filing of an indictment or information, step 10, after the filing of an indictment or information. A decision not to proceed at the first stage simply results in the complaint not being filed, leading to the common description of that decision as a no-paper decision. and the release of the arrestee from police custody without any involvement of the judiciary. A decision not to proceed at that stage commonly occurs in connection with the prosecutor's review of the case against a defendant prior to presenting it to a magistrate at a preliminary hearing, step 8 infra, or to a grand jury, step 9 infra. This decision commonly is formalized in a prosecution motion before the magistrate to withdraw the complaint, although where grand jury review is being used, the prosecutor can ask the grand jury to vote against indicting, which similarly terminates the prosecution. A decision not to proceed further in the third stage, i.e., following the filing of an indictment or information, requires a prosecutor's no wish to prosecute motion, which must be approved by the trial court. The combination of the 3 non-prosecution decisions typically accounts for the disposition of a significant portion of all felony arrests. So these are non-prosecution decisions. Prosecutorial review of the police charging decision prior to the filing of the complaint must occur in a short time span, as the arrested defendant must be brought before the magistrate within 24 or 48 hours. See step 7 infra, and the complaint must have been filed at that point. Not surprisingly, there is considerable variation among prosecutors' offices as to the scope of their review at this stage, with some largely leaving the decision to file the complaint to the police and delaying their initial review of the charge in most felony cases until the second stage noted above. Where a prosecutor decides against proceeding in the prosecutor's initial screening of the police department's charging decision, whether before or after the filing of the complaint, that conclusion most often will have been based upon anticipated difficulties of proof, i.e., the evidence is insufficient to convict, the victim is reluctant to testify, the key evidence was obtained illegally or therefore will not be admissible. However, the prosecutor may decide against prosecution even though the evidence clearly is sufficient, because there exists an adequate alternative to prosecution. For example, the arrestee is willing to participate in a diversion program, or the arrestee is on probation and can be proceeded against more expeditiously by revoking his probation, or special circumstances render prosecution not in the interest of justice. A decision not to proceed made on re-examination of an earlier decision to prosecute, the typical situation where the prosecutor decides to drop charges at the third stage, is most likely to be the product of a change in circumstances that has either eliminated the need for prosecution, i.e., the defendant has been convicted of other charges, or substantially reduced the likelihood of success. Critical witness is no longer available. Where the prosecutor in the initial screening process decides in favor of the criminal prosecution, other decisions must also be made. Initially, the prosecutor must determine whether the proposed charge is set at the correct level and whether there is a need to reduce or raise the offense level recommended by the police. In any instances, the prosecutor must also consider the potential for charging multiple separate offenses, as where the arrested person allegedly committed several separate crimes in a single criminal transaction or engaged in more than one criminal transaction. Here, the prosecutor must determine whether the charging instrument should allege all offenses or simply some of the offenses, for example, only the most serious or only those easiest to prove. Where the prosecutor chooses to proceed on more than one charge, the law may give to the prosecutor another choice whether to bring the charge in prosecution or in multiple separate prosecutions. A similar choice must be made where several people have been arrested for their participation in the same crime, as each can be proceeded against separately or as a group can be prosecuted jointly through a single charging instrument naming multiple defendants. I'm going to stop before step 5, filing a complaint.